Good evening, everyone. Honorable dignitaries and esteemed guests, I, Prachi Bhardwaj, on behalf of EBC, feel deeply honored to welcome you all on this momentous occasion where we gather to celebrate the release of the book Mediation in Insolvency, a Game Changer in Viksit Bharat, edited by Justice A.K. Sikri and Mr. Sumant Batra and published by EBC. This remarkable book features contributions from some of the world's leading experts in insolvency and mediation, and it promises to serve as a valuable resource not just for practitioners and students of insolvency policy and practice, but also for anyone involved in the transformation of India's insolvency and dispute resolution ecosystem. To mark this occasion, I would like to extend a warm welcome to the distinguished dignitaries on the dais. It is with great pride that we welcome our chief guest for the evening, whose journey through the corridors of justice has been nothing short of remarkable. Justice Surya Kant, who began his illustrious career in Hisar in 1984, has consistently set benchmarks in the legal arena. From becoming the youngest Advocate General of Haryana in 2000 to his elevation as a judge of the Supreme Court in 2019, his trajectory is a testament to unwavering dedication and profound legal acumen, and his impactful judgments underscore his commitment to justice and constitutional values. It is an honor to have you here with us, sir. I would like to request Vaidehi Gulati to felicitate Justice Surya Kant. Please join me in welcoming Justice Manmohan, a stalwart in the Indian judiciary whose journey reflects a steadfast commitment to justice and equality. Enrolled as an advocate in 1987 and designated as a senior in 2003, Justice Manmohan's legal prowess quickly propelled him from the bar to the bench. In 2008, he took on the esteemed role of an additional judge of the Delhi High Court, and by 2009, he became a permanent judge, further solidifying his legacy. Now serving as the Chief Justice of the Delhi High Court, his influence continues to resonate throughout the legal landscape. It is an honor to have you here with us, sir. I would request Bhumika Indulia to please felicitate Justice Manmohan. It is with great admiration that we now welcome our next guest of honor, Mr. R. Venkatramani, the Distinguished Attorney General for India. With an impressive 42 years of experience across various legal disciplines, he has consistently proven himself to be a defender of justice and individual rights. His contributions to the legal field not only inspire future generations of lawyers, but also reinforce the vital role that legal professionals play in safeguarding democracy and justice in our society. We are truly privileged to have you here with us, sir. I would request Kriti Kumar to felicitate Mr. Venkatramani. It is a privilege to welcome our next guest of honor, Mr. Amitabh Kant, the dynamic G20 Sherpa of India. With a distinguished career in the Indian Administrative Services since 1980 and as the former CEO of Niti Aayog and Secretary of the Department of Industrial Policy and Promotion, Mr. Kant has been a driving force behind the transformative initiatives such as Make in India, Startup India, Incredible India, and Kerala, God's Own Country. Mr. Kant's contribution have truly left an indelible mark on the nation's progress. We are privileged to have you here with us, sir. I would like to request Apurva Goyal to felicitate Mr. Kant. Please welcome Justice A.K. Sikri, a trailblazer whose illustrious career has redefined the contours of justice in our nation. With a remarkable career spanning over 4 decades, Justice Sikri has not only shaped the landscape of constitutional law, but has also championed labor rights and arbitration with unparalleled fervor. With over 400 Supreme Court judgments to his name, Justice Sikri stands as a beacon of integrity and a champion of justice. With this groundbreaking book, Justice Sikri, along with Mr. Sumant Patra, is set to transform India's insolvency and dispute resolution ecosystem. We are glad that you found time to collaborate with all the experts from all over the world and give us this book. Thank you, sir. I would like to request Shubhra Venkat to felicitate Justice Sikri. It is now time to welcome Mr. Sumant Patra. With 3 decades of global expertise in insolvency and bankruptcy, Mr. Batra is the only Indian to have been conferred the honor and election as an international fellow by the American College of Bankruptcy. He also holds a distinction of being the youngest and the first president of Insol International from Asia. Beyond his legal prowess, Mr. Batra is the creative force behind initiatives that celebrate India's rich heritage and literature. Together with Justice Sikri, he is poised to revolutionize India's insolvency and dispute resolution ecosystem with this book. Thank you, sir. Again, it is a great deal. I would request Anushka Basu to felicitate Mr. Batra. Founded in 1942 by two brothers, EBC has grown from its humble beginnings in law book selling and publishing to India's largest legal publishing house that serves as a vital research source for legal professionals and students. As the director of EBC and associate editor at Supreme Court cases, Mr. Sumit Malik, with his visionary leadership, has propelled the organization to new heights. His strategic insights and innovative approaches have significantly contributed the growth and prominence of EBC. In addition to his role at EBC, Mr. Malik serves as the head of the finance chair at the Entrepreneurs Organization, Uttar Pradesh, showcasing his versatility and unwavering commitment to excellence. I would request Sarisha Chawla to felicitate Mr. Malik. I would now like to request Mr. Sumit Malik to address the august gathering.
My Lord Justice Surikant, My Lord Justice Manmohan, Mr. Venkatramani, Learned Attorney General, Mr. Amitabh Kant, G20 Sherpa, our authors, Justice Sikri, Mr. Sumant Batra, Honorable Judges, Learned Senior Advocates, students, and gentle people. It is my privilege and pleasure to welcome all of you to this event where we will be celebrating the release of the book on mediation in insolvency, a game changer in Viksit Bharat. I am grateful to our Chief Justice and the Chief Guest and our guests of honor for taking the time out to participate in this event. I can now safely say that we have now long associations with Justice Sikri and Sumant Batra. This co-authored book is their second with EBC. If you in the audience have attended some of our earlier book releases, you may have heard what I am about to say, but I say it again. In this new world of technology and artificial intelligence, ChatGPT, which allows for instant self-publishing, publishing on blogs, etc., the question is, how do we at EBC see ourselves? What is the role of a publisher? In today's context, I can say that we see ourselves as the trustees of the legacy of authors. We have, over the years, continued to preserve the legacy of authors, names that are synonymous with the study and teaching and practice of law. Professor V.N. Shukla, Professor Kelkar, Dr. Avtar Singh, Professor Ahmed Siddiqui, Sri V.D. Mahajan, Sri V.G. Ramachandran, Professor T.K. Tope, Professor B.M. Gandhi, and others. In addition, it also means the publishing of material on the forefront of legal thought. Mediation as a form of dispute resolution finds its roots even in ancient texts and is deep-rooted in the Indian way of life. Dr. Bibek Debroy, in his chapter, calls it the Dharma Shastra tradition. There is always an elder in the family to whom a family dispute would be referred to. A community elder who is happy to mediate in a dispute between two neighbors. Even formally, many mediation rules have been enacted by states and high courts under provisions of the CPC even before the Mediation Act 2023 was enacted and enforced. To be able to use mediation as a dispute resolution mechanism in insolvency proceedings, some of which could be multi-million-dollar proceedings, would truly be a game changer in Viksit Bharat and help unburden our already overburdened court system. There is very little material available on formal mediation, let alone mediation in insolvency. This work, which is before you, which has insightful chapters from the top names in the world, straddling both the insolvency and mediation world, will be extremely useful to the insolvency practitioner. A book, as I see it, is a custodian of thoughts and ideas, whereas judges, while deciding cases, are bound to decide the list before them on a given set of facts and apply the law to those facts. Authors, when writing books, do not face such limitations. A good author will explain the law to the audience, but a great author, and in this book there are many, will also show the light forward by placing their thoughts and ideas in form of a book and what they consider the law ought to be. The authors who have contributed by writing chapters have done exactly that. As we at EBC enter our 82nd year since incorporation, what we have learned is to understand what the legal profession requires and what our role can be in fulfilling that requirement. We believe that our role is to bridge the gap between legal information and knowledge and those who consume that legal information and knowledge. As a third-generation member of this publishing house, I have been blessed and to be having shown the way by my elders. My granduncle and grandfather had very humble beginnings, delivering books on bicycles to lawyers, including the great Dr. Ambedkar, when they started off as booksellers in 1942. But even then, the mission was clear: provide a service which will assist the practitioner in her work. The mission continued with the same spirit when EBC started publishing books for lawyers and students in 1947. The books we produce must necessarily be of very high quality and assist the user in their quest for knowledge. To be effective in our role, it is important that the materials or content that we produce is authentic, accurate, and reliable. Also, we've continued to innovate over the years to keep ourselves relevant. In 1969, when Mr. Suren Malik graduated from the Delhi University, having studied by the newly introduced case method, he realized that there was a need for faster reporting of Supreme Court judgments. Thus came about the innovation of Supreme Court cases, or SEC as we know it today. As you're all aware, there can be no second edition of a law report, and it must be got right the first time. Prompt, accurate, and complete has been our philosophy, which we have adhered to since then, and we understand and recognize our responsibility that the honorable judges in bar rely on SEC. He has now taken up the onerous task of reporting judgments of the Supreme Court since 1950 till 1968, a period not covered in SEC earlier. In just the first 10 volumes published, we discovered and reported many important judgments of 4 judges and 3 judges that have never been reported before. With High Court cases, HCC, our newly launched venture, we begin the journey to report judgments of the High Courts of India with the same alacrity and comprehensiveness as we report the Supreme Court. EBC has recently welcomed Company Law Institute into its fold and is now offering the famed ITR, company cases, goods and services taxes reporter in both print and electronic form to our subscribers. EBC was amongst the first Indian publishers to introduce a legal research database on CD-ROM in 1996. Which was less than 650 MB in size, and now the SEC Online Web Edition has grown to over 20 terabytes of data, 5.4 million documents covering over 300 jurisdictions around the world. Even though we believe that the printed book is not going away, yet for the tech-savvy, EBC's EBC Reader platform is ready and has over 400 books, and we add new ebooks to it every day. SEC Times, a web-based blog on which we report proceedings in court, law schools, and the like, has now over 1 million views and over 500,000 visitors every month. It is being relied on by an increasing number of legal professionals as their source for authentic and analytical legal news. Consistently innovating, EBC's newest service, EBC Learning, an e-learning platform, and Mercury, a judgment tracking software, has already gained loyal users. We are also fortunate to have as part of the EBC family a dedicated team of legal editors, software engineers, DTP staff, proofreaders, sales and marketing staff, and managers who are as much, if not sometimes more, invested in ensuring that what is produced from the House of EBC is of high quality, authentic, accurate, and reliable. This has been a wonderful experience working with Justice Sikri and Mr. Batra on this book. Mr. Batra has already begun revising his book, Corporate Insolvency. He is already one of the foremost authorities on insolvency, and I'm sure that when the work is out, it will be a reflection on how well we have done till now and a guiding light on the way forward. I cannot end without acknowledging, there will be a formal vote of thanks, but without acknowledging the efforts of Prachi Bhardwaj, Bhumika Indulia, Nilufar Bhateja, Apurva, Shubhra, Kriti, Anushka from the EBC team, and Vedehi Gulati, Shiv, Shivani, Sarisha, Vandana, and Sandeep from the Insolvency Law Academy team in putting together this event together. Thank you. Jai Hind.
Thank you, sir. I would now like to invite Mr. Batra to address the audience.
Thank you. Honorable Chief Guest Justice Suryakant Ji, Judge, Supreme Court of India, Shri Justice Manmohan Ji, Chief Justice of Delhi High Court, Shri R. Venkatramani Ji, Attorney General for India, Shri Amitabh Kant Ji, G20 Sherpa, very distinguished guests present in the room, including the authors in this book. On behalf of Justice Sikri, Honorable former Judge of the Supreme Court of India, presently International Judge, Singapore International Commercial Court, the co-editor of this book, I express my deep gratitude to all of those who are present here to share with us this moment of happiness and also a big stride in the way of trying to build a robust insolvency system in the country. When Insolvency Law Academy was conceived in June 2022, it was following a nudge by late Bibek Deb Roy ji, where we were discussing a kind of an update on how the IBC is performing. And he suggested that we should have a first-class research institute on insolvency, which meets global standards, provides cutting-edge research, which can guide policy making and help standard setting in insolvency. The first thing that was done after the institute was set up, I met Justice Sikri and requested him to chair the Global Advisory Board of very, very many eminent people, including from the World Bank, IMF, and Insol International, and other streams of insolvency from around the world. And when we sat down to sort of discuss the vision and the agenda for the ILA for the next 5 years to 7 years, at least, one of the things that he suggested, alongside many others, was that we should certainly see how and explore if we can make use of mediation in insolvency. This was alongside other subjects that we were looking at: climate change, building scholarship in insolvency, looking at some other areas where we thought that we can take thought leadership of insolvency around the world. We've come a long way in the last 2.5 years. We have produced a good body of work already, a number of research papers, but this is our first collaborative effort to come out with a publication in partnership with EBC, which we believe will take thought leadership in this area, not just in India, but also beyond. We believe that insolvency law was intended to be and generally is globally non-adversarial in nature. Yet, disputes do arise amongst parties, between parties, before or after or during the admission or the process itself. Most of these end up at the doorsteps of NCLT, clogging its board and unfortunately delaying the processes. And we thought that mediation could emerge as one of the possible policy choices as well as a practice choice which will enable parties to resolve a lot of issues by use of amicable procedures such as mediation. And that is how the idea of the book came. Because there's no comprehensive literature on this, whether globally or in India. There are, of course, a number of essays, there are a number of research papers, there are a number of thought papers on this subject, but there's no comprehensive single book on mediation. And we thought maybe that's an opportunity for us to take lead in this area, and we decided then to narrow down on who all we should approach for contributing essays. And I'm so delighted, and of course I feel humbled at the same time to say that we have been able to get support of, and we have them in the shape of essays in the book from the top policymakers in the country, including from the Prime Minister's office. We have honorable former judges of the Supreme Court. We have the insolvency regulator. We have the World Bank. We have the Insolvency International, which is the global federation of insolvency community fraternity in the world. We have some of the judges from abroad who have great experience in this subject writing. We have American Bankruptcy Institute writing. We have some of the top minds in this country as mediators or as insolvency professionals, as even academics who have contributed. We have 26 essays from some of the top minds around the globe, including, of course, from our own country. And the whole idea is that we should be able to shape the narrative on this subject and to see how we are able to contribute to make insolvency law more robust going forward by applying mediation as a powerful tool. One of the last things that I want to mention is that you will find in the book as a last essay as Arun Jaitley Mediation Center. About 2 years ago, Arun Jaitley Foundation and Insolvency Law Academy collaborated and decided to set up a mediation center which is dedicated to late Arun Jaitley ji, and which is aimed for becoming one of the most sophisticated, topmost global mediation center by the market itself, which will complement the efforts of the policymakers and the institutions that are being set up by the government with the blessings of the government and, of course, with the blessings of the Supreme Court as well, and to see how we can provide a competitive private sector institution which will train, create capacity, and also, in times to come, offer mediation services. So with this, I once again express my deep gratitude to all those who have contributed the essays in the book, and I also express my thanks to the honorable dignitaries who have accepted to launch this book today for us. Thank you so much.
Thank you, Mr. Batra, for that amazing introduction to the book. On that note, before we proceed any further, I would like to request our chief guest, Justice Surya Kant, to please release the book for us. I would also like to request all the distinguished dignitaries on the dais and Mr. Surendra Malik, Managing Director, EBC and Chief Editor, Supreme Court Cases, and Mr. Sumain Malik, Director, EBC and CEO and Founder, SEC Online Division, to join us on the stage to commemorate this momentous occasion. What a wonderful sight to behold. Congratulations to all. I would now like to invite Justice Sikri to say a few words on the occasion.
Thank you and good evening to all of you. My two dear brothers sitting on the dais, Justice Suryakant and Justice Manmohan. My two very dear friends sitting on the dais are Attorney General Mr. Venkat Ramani and Mr. Amitabh Kant. Mr. Sumant Batra, very, very dear to me in so many ways. And Mr. Sumit Malik, who is the creator of today's product, if I may say so, along with his team from EBC. All the very, very special persons in the audience, including Mr. Sahu, the first chairperson of IBBI. And what I find in the audience is persons of our own family, as I call mediation family. I think everybody who is sitting in the audience is not only committed to mediation, the cause of mediation, they have been working tirelessly to achieve the miracles and magic of mediation work in this country. So my thanks to everybody who is here in the audience today. As I have mentioned that all of you are so well versed with the mediation, so I don't have to tell you about the magic and miracles of mediation, because as I said, you are producing that magic and you are achieving those miracles day in and day out while resolving so many disputes through mediation every day. But I would only say, as far as the journey of mediation in this country, from 2005, when the first mediation center as a project, pilot project was set up in Tisarari in Delhi, and immediately thereafter in Delhi High Court, and now almost every nook and corner of this country. We have realized that in many ways, mediation is a better form of access to justice, and it's a better form of even arriving at more just resolution of the disputes when compared with other systems. In many ways, when I say under many, many circumstances, it proves to be so. Secondly, it's a good substitute for adversarial system, which normally the courts and arbitration adopt. Again, there are many disputes which are not to be litigated in an adversarial system, and mediation becomes a savior in all those disputes. Number 3, which was the main purpose for which the mediation was introduced in this country after seeing its success in the West and more particularly in United States, that the courts are clogged with dockets, and this is one form of alternate dispute resolution which will ease the burden of the courts. And the number of cases, of course, we are still struggling with the areas in this court, in our legal system, but notwithstanding that, we don't know the lakhs of cases which have been settled through mediation only in Delhi, and if we take the figures of all India, it may be much, much more, the burden of the courts would have been much more than what it is today. And as we are progressing towards the success of this mediation, and mediation is becoming really popular, I think the burden of the courts is going to be reduced in future, which we are looking forward to. I say, even in the context of arbitration, that of course I would not say that it is lessening the burden of arbitration, but in fact it is proving to be more potent weapon, and that is my hypothesis and my belief, that it is becoming more potent weapon to salvage in the situation in which this arbitration is today. Arbitration was conceived as the alternate dispute resolution system, which would be more speedy and which would be cost effective. Over a period of time, we have realized that has not been happening. But in order to popularize arbitration more, all institutions, arbitral institutions, have also understood the importance of mediation, and that is why this Med has started. Why even mediation is introduced in arbitration shows the significance of mediation as far as the dispute resolution mechanism is concerned. And it is because of this reason mediation which is gaining popularity. Initially, again, when it started here also, we thought, and in many other countries as well, that as far as mediation is concerned, it was good for family disputes, it may be good for the matrimonial disputes, etc., and maybe other small kinds of disputes. Over a period of time, it was realized, no, it is very good for even settling the commercial disputes and international commercial disputes as well. That's the reason for last number of years now, when it comes to settling the international commercial disputes, which are becoming more and more complex, that the mediation is resorted to. I don't know what's the reason. I'm giving you one interesting figure or a statement or a news which may not be good for me personally, that in last 4 months or 5 months, my 4 international arbitrations which were going on have been settled. Maybe lost to me personally, but it shows that the parties want to settle the disputes through mediation. And another step which is now mediation is taking is that it is going into some sectors which were hitherto unknown or known as the sectors where mediation may not be possible. Tax disputes, for example. Nobody can today think that a tax dispute where there is a dispute between the revenue and the assessee can be settled through mediation. May not be in that sense, but yes, initially, if it is a dispute between a public sector undertaking or some semi-governmental body and the government, that is tax department, it is possible. And I think today people may think, and even the government may think, that it may not be possible, that time will come and show that it is very much possible. And time doesn't permit, but I have my own experience, I have gone through that, and I can say so with certainty. Insolvency is now, to which I come to, is another such field. Till few years ago, it was thought that insolvency is one aspect, and there were so many complex issues which arise while carrying out the CIRP, which we call resolution process, etc., the plan which is to be submitted. It may not be possible. It is now realized that rather, if you go through the insolvency process, and those who are familiar with insolvency law know that at many steps, it is the mediation which is more fruitful rather than deciding those cases or those aspects by either the committee of creditors or by the IPs, insolvency professionals who are appointed, because in whatever way they decide, the matter would go up to the Supreme Court. Although it has to be a collaborative effort, and why not through mediation? It is in this process, as I would not repeat that what Mr. Sumant Batra has already said, how ILA was conceptualized and was formed, and the progress which it has made in last 2.5 years. But then we know, and we have come to know, and we have seen many conferences, international conferences on insolvency which I have attended, many institutions including the courts, etc. Everybody is today talking about mediation in insolvency. And they think that insolvency is and it is even in SICC, of which I am international judge. Every conference which we have, this is the hot topic of discussion. So therefore, in that context, as Mr. Sumant Batra has already informed you, we thought that, look, there is literature, people are writing about it, it is becoming relevant, but why not have all this wisdom in one place? So this is, of course, I must give credit to Sumant. It was his idea. Thereafter, it became a collaborative effort that we chose the persons who can write on this, either those who are good in mediation or those who are good in insolvency, or there are many, Mr. Chandok sitting here, who is good in both. So we requested those persons from abroad and within India. We have Mr. J.P. Singh sitting here, Mr. Chandok, Iram Mazid, who have all contributed. I think Madhvi Diwan has also written one, has contributed an essay. So it talks about in length and breadth various different aspects of mediation in insolvency. And let me tell you, even for mediation world, those who are doing mediation, when, of course, the general principles or the procedure which is to be followed and what is to be done by a mediator is known. But when it comes to specific field, there are certain nuances which are to be kept in mind. And this book is going to be very helpful in that sense. That is my belief. So with this, I thank everybody. I profusely thank all the persons sitting on the dais. Justice Suryakant has graciously contributed. He has written forward to this book. Justice Manmohan, Chief Justice, when I requested him that can we have the function here, very graciously and immediately agreed to that and said that you are most welcome. When I requested Attorney General to be here at this moment, he said that when you say so, I will not say no, and that is the affinity which we have, and so was Amitabh Kant. So thank you very much, everybody, and I think you are going to really relish reading of this book. Thank you very much.
Thank you, Justice Sikri, for that insightful address. I would now like to request Mr. Amitabh Kant to please come and address the audience.
Honorable Justice Suryakant, Judge of the Supreme Court of India, Honorable Justice Manmohan, the Chief Justice of the High Court of Delhi, the distinguished Attorney General of India, Honorable Mr. Venkatramani, the multifaceted Justice Sikri, who's been a judge, writer, editor, great speaker, many things rolled into one. Mr. Sumant Batra, the co-editor of this book. Mr. Sumit Malik, the director, EBC Group of Companies. Distinguished guests, ladies and gentlemen. The ambition of India is to be a Viksit Bharat, a developed nation, by 2047. This implies that India's GDP has to grow from roughly about 3.7 trillion to about 40 trillion by 2047. And this implies that your GDP has to grow by almost 10 times, your per capita income has to grow 9 times, your manufacturing has to grow about 18 times. And this is not possible without speedy resolution of commercial cases and without mediation being a very inherent part of insolvency. This volume of mediation in insolvency, a global perspective, represents a very significant contribution to the evolving field of insolvency law and dispute resolution. Particularly in India, where the Insolvency and Bankruptcy Code has ushered in very transformative changes in our financial ecosystem. The IBC has marked a very significant shift in India's approach to financial distress. Once India was characterized by the notion that India had transitioned from socialism without an entry to capitalism without an exit. This paradigm shifted with the introduction of the IBC, which provided a much-needed mechanism to address insolvency issues in a time-bound and efficient manner. The IBC has played a transformative role in the Indian economy. At the time of its enactment, many of you would recall, we were dealing with a twin balance sheet crisis where non-performing assets were hovering close to around 12%. This resulted in the choking of fresh credit, which is the economy stalling economic growth. The IBC emerged as a lighthouse of a new era, ushering in what Justice Nariman had eloquently paraphrased from John Milton as a defaulter's paradise lost. It engendered a culture of corporate accountability and credit discipline. A behavioral shift occurred where borrowers realized that they needed to repay their debts. NPAs are now at a historic low, bank balance sheets are robust, credit is growing at a healthy clip. The IBC has so far been successful because the entire ecosystem and the institutional infrastructure came together and played their part. However, as we look at 2024, we must acknowledge some major concerns regarding the present functioning of the IBC, indicating a need for a second generation of reforms. Analysis of IBBI's own data shows that insolvency resolution at the National Company Law Tribunal averaged 716 days in the last fiscal year, up from 654 days in 2022-23. More concerning is the average time taken for the admission of cases, which stood at 468 days in financial year 21 and increased to 650 days in financial year 2022. Recovery from defaulters under the Insolvency and Bankruptcy Code has actually decreased in 23-24 from the previous year. The rate of recovery fell to 27% of the creditors' admitted claims in 2023-24 from 36% in the previous year. Ladies and gentlemen, the creditors are applying for admission under IBC more than 2 years after the account has been NPA. Delay in filing applications is leading to a loss of value for the asset. The IBBI studies show that about 50% of value is eroded before the companies are admitted to IBC. Therefore, it is necessary that the creditor should apply for admission as early as possible. But as we all know, there is an inverse relationship between time and value, and accordingly, the delays are depressing the values recovered. And to my mind, for maximizing the values of a debtor's assets, mediation will have to play a critical and a very significant role. Mediation is not a new concept in the world of dispute resolution, but its application within the context of insolvency is very relatively normal, very novel, and the need for consensual, flexible, and non-adversarial approaches to resolving insolvency disputes has never been more important than now. Mediation allows stakeholders, whether creditors, debtors, or other involved parties, to find mutually agreeable solutions without resorting to lengthy and very costly litigation. This shift in mindset is crucial for the efficient functioning of insolvency proceedings, enabling timely resolutions and preserving the viability of businesses that may otherwise have been lost in protracted disputes. The contributions of Justice Sikri and Mr. Batra to this book and to the field of insolvency law cannot be overstated. Justice Sikri's illustrious career, both in India and internationally, has shaped the legal landscape in ways that will have a lasting impact on the administration of justice. He chaired several significant committees when I was CEO of Niti Aayog, and his contribution has been immense. His involvement in this book brings a wealth of experience and insight into the intersection of law, mediation, and insolvency. Similarly, Mr. Batra's global eminence in the field of insolvency law is unparalleled. His deep involvement in shaping the insolvency reforms in India and his leadership in global insolvency organizations have made him a cornerstone of this field. The book is a reflection of the combined vision and commitment to advancing insolvency resolution in India and across the world. Mediation as a tool for dispute resolution holds immense promise in advancing the goals of the Insolvency and Bankruptcy Code. In a country like India, where the pace of economic development is accelerating, the need for timely, efficient, and fair resolution of insolvency cases is paramount. Mediation can be the bridge that helps us navigate these challenges, providing a pathway to solutions that are not only legal, but also sustainable. This book will serve as an invaluable resource for legal practitioners, policymakers, students, and anyone involved in the insolvency and mediation ecosystem. It not only outlines the theoretical underpinnings of mediation in insolvency, but also offers practical insights into how mediation can be applied effectively in real-world scenarios. By addressing complex issues, fostering dialogue, and proposing acceptable solutions, this work has the potential to shape the way insolvency disputes are resolved in the years to come. My heartfelt congratulations to Justice Sikri, Mr. Batra, and all the contributors to this remarkable work. It will have a lasting impact on the discourse around insolvency and mediation globally. Let me just say that this book launch marks a very significant milestone in the continued evolution of India's insolvency and the dispute resolution ecosystem. I wish the book a grand success. Thank you very much, ladies and gentlemen.
Thank you, Mr. Khan, for that insightful address. And we all hope that the dream of Viksit Bharat becomes a reality much sooner than 2047. I would now like to request Mr. Venkatramani to address the audience.
Justice Sikri has gathered the creamy layer of the Delhi here on the dais and in the audience. And the two honorable judges who are here with us, I think are right choices to be on an evening like this, because both of them, as they know, are so concerned, involved, and in the pursuit of promoting the values of mediation. And with Amitabh Kant, whose articulate endeavors as being a Sherpa, I had occasion to listen to him once or twice, and I think he was also a grand mediator in making our G20 happen. Some of those stories are very exhilarating. So you have a very exciting set of people on the dais. So that's a and that's a good indication of how the book will fare in times to come. So I remember July 2023 in this auditorium we had the launch of Judge Sikri's book of Constitutional and Rule of Law in the Theatre of Democracy. So he has chosen another theatre, the theatre of settlement of disputes in an area where everybody has a lot of doubting Thomases. So many of us are doubting Thomases about what mediation can do and cannot do in what we think are areas which are beset with a lot of challenges and problems and all that. But I suppose something which must have made him very curious and beyond, we have an interesting contribution here by Sriram Panchu. Just Sikri and myself know just Panchu, and many of our friends here know him so well. And one of his earliest books was, Settle for Less. The title of the book was Settle for Less. And then he moved on to convince the importance and the value of mediation not only in India but abroad. So this book has an important article contribution by him. But he says, what is the IBC going to do in the world of getting justice for people who are in darkness about what is their future in resolving the disputes? And he is a very forcefully written piece in this. I thought I should read the rest of the contribution before I read his article, because I can become a little biased in looking at the possibility of settlements or the lack of it in the insolvency field. But then as I read through some of the articles relating to the Commercial Courts Act or mandatory versus directory, and all a wonderful piece of thoughts and ideas which egg us on to go beyond the pedantry ways of looking at mediation and things like that. So as we try to enter into this debate, before I come to Sriram Panchu's very incisive piece and how it gives us a very important perspective on how you look at mediation and all that. So I was trying to pick up some ideas today. You cannot come on an important book launch like this without having prepared yourself, at least minimally, if not fully. So I was looking at described litigation as a machine which you go into as a pig and come out as a sausage. I think it's an important, very important, significant statement. So if you want our adversarial legalism, because I think over a period of time across continents, the ability and the cultural inclination of people to settle disputes without getting into formal dispute resolution processes was lost over a period of time. The civilizational value was lost. So we get into a adversarial legalism. One of the authors who wrote a book somewhere in 1992, I think Leonard Rosenthal, who talked about the values of how adversarial legalism had produced different outcomes in France and England. In the context of France, it went into a different direction. In England, it flourished. So adversarial legalism, even in different parts of Europe, had seen different outcomes. So the cultures or the nuances of adversarial legalism in different countries that produce different outcomes. But what do we learn from an adversarial legalism? How long are we going to be tied up with? Important for us not really look at what called the pedestrian ways of whether making mediation and mandatory or making it directory and so on and so forth are one level of looking at mediation and the values of mediation. We need to get into a different higher levels of looking at that. So how do we therefore, I thought this book is an important initiator to go beyond those what we call the legalistic pedestrian ways of looking at mediation and its prospective contributions. So I was also looking into the book on two important contributions. I thought I was refer to them because another article in the same book talks about how it says those who criticize settlements suffer from what I have called in other contexts, litigation. I think it's a very important way of looking at it. Because now we become so involved in the adversarial legalism that we become romantics with litigation. So whenever there is a possibility or a scope or a debate which is initiated or assured, to look at other ways, the theatre of IBC, two important theatres where this book, I'm sure. So I think I must congratulate both Justice Sikri and our Sumant Batra on the very important contribution. But I have a few more reflections before I conclude. Now, we talk of party autonomy in arbitration, right? It's sacred. But we don't talk of party autonomy in mediation. Why not? Because after all, party autonomy towards the very persuasion to become autonomous and be participating in settling your disputes, what is its value as compared to a party autonomy in arbitration? Party autonomy in arbitration is enforceable. So we still have not reached a stage where the importance and the sacredness of having contracts drawn, where mediation will have a certain, fundamental value. And then therefore, then we do not get into the question whether a statute should provide something should be mandatory or directory. So if parties are persuaded to move into an entirely different, what called perspective and approach to dispute resolution. Somewhere I find even the dispute resolution word has been borrowed from an adversarial legalism. Probably we need to look at some more better or more persuasive expressions and things like that. So if that is how it is, why can't we go into a stage where universities, law schools, and courts also began to talk of the importance of contractual phrases where mediation will become an integral part of mediation settlements and all that. And if Mr. Khan talked about the rate of decrease in resolutions in the IBC field, it can be traced to many factors. Like you use from DRT to SURFACE, then we have had the SICA Act, and then we into IBC. So if you trace the evolution of those efforts, then every effort has been, I think, confronted with the internal conflicts which the law did not perceive when the law was enacted. So IBC will probably face that in sooner or later. But that's not a criticism in a negative way. Because many of these, that's why if you talk about an adversarial system and to try to build all procedures around them, I think the procedures begin to bother us. The procedures begin to drag us. They become dragging factors. Whatever one may say about the importance, or for instance, the Commercial Courts Act, there have been several amendments. So how far your procedures will become a confronting element. So I think, therefore, as long as we stick on to an adversarial legalism in our dispute understanding and dispute resolution, we'll be tied up with these issues. So it's important that Sikri has opened our eyes to looking at dimensions which would not normally perceive. They are built into this book, but I think it's not a book for a one-time attention. It's a book which calls you to keep reading again and again, not only for your own reflection, but for you to share those reflections with the legal community in order that So sometime back we thought we were talking about ad hoc versus institutional arbitration. And one idea was to bring in an arbitration bar. We could probably try to improve or probably fasten an important element in institutionalizing arbitration. So in the course of time, I also thought, I've been speaking to many people in the bar, that we'll have a national mediation bar. And this mediation bar will probably be part of looking at, and after all, when the initial days of legal aid, people wanting to do legal aid services, were not very favored lawyers, right? You belong to a slightly lesser level of your legal practice. But today it's very different. And I think it's important for us to say that as long as and as far as people who enable people to settle disputes will stand in the higher echelons of the bar, I think that will be a great index of the service to the nation. Therefore, I would welcome all possible thoughts and ideas on how to have a national mediation bar, and we try to spread as far as possible and as wide as possible and as intensely as possible. So I think, thank you for inviting me here today. I thought I'll share these humble ideas with you. I think the book will travel far and wide, and And I'm sure if anywhere you need any one of us as party, your journey partners, we are there to help you with. Thank you so much.
Thank you, Mr. Venkatramani, for that insightful address. Now I would like to request Justice Manmohan to please address the audience.
Respected Justice Suryakant, Mr. R. Venkatramani, Mr. Amitabh Kant, Justice Sikri, Mr. Sumant Batra, the members of the EBC family, distinguished ladies and gentlemen. See, the title of the book I find is very, very interesting. It says, Mediation in Insolvency, a Game Changer in Viksit Bharat. According to me, a Viksit Bharat means a nation that is developed, that is fair, and that is economically prosperous. How do you do that? You do that by ensuring that private enterprise in the form of companies, in the form of industries, flourishes. People who set up industries, who set up big companies, they always take a chance. No one is sure that the business will grow and they'll be successful. So there is always a downside that the business may not succeed, the venture may not succeed. If that is so, then we have to have a proper mechanism to deal with the financial distress that is generated by the failure of that venture. In any growing economy, you cannot have too many stressed loans, too many stressed assets. You have to ensure an expeditious resolution of the dispute, and the dispute must be resolved to the satisfaction of all the stakeholders. When I was a lawyer, I was primarily practicing on the corporate side, and I can tell you that the interest of the stakeholders can be very, very different. The employees' interest in settlement may be entirely different from what the investor's interest may be, or the shareholder's interest may be. There would be creditors who would be looking at it from a totally different prism. There would also be third-party contracts which would have been executed midway, who would be looking at the scheme of rehabilitation, amalgamation from a totally different perspective. How do you bring these competing interests on the table and resolve it expeditiously? Taking a very legalistic approach in the court process, especially in a system which is already overburdened, we see that day in and day out. We all know even our NCLT are overburdened. A large number of writ petitions are being filed seeking early hearing in the matters which are pending. So the system, the judicial system, has a limited capacity. But in a country which is growing and growing at a remarkably fast pace, I think we'll need to look for new tools to resolve disputes and to resolve them at a fast pace. I think mediation is one of the tools that we need to try. I expect that it could be a game changer when it comes to resolving disputes in insolvency. There are some inherent advantages, as we know, of the mediation process. One is it is flexible. It is not to be done in a straitjacket manner. When law is administered, it is normally done in a very straitjacket manner. The procedure will have to be followed. Notices will have to be issued. Everyone will have to be given a written notice. You will have to see his reply, then decide. And it may not be possible in a legalistic manner to balance so many interests that we have to deal with. In insolvency, that flexibility that you have of accommodation that can be done, I think you can achieve that result nowhere else. It will also ensure that it is cost effective. And the most important aspect that I see in this tool is there is confidentiality. People in the business world are very, very touchy about matters or the word spreading around that their companies are not doing well. So therefore, I think it's one of the characteristics of the mediation process is confidentiality, and that I think is of great significance. Also, the inherent concept in mediation is that it is fostering a spirit of cooperation and collaboration, and not a spirit which gets really promoted in the adversarial system is who gets priority. So in this adversarial system, the question is who will prevail. That attitude is entirely different, or the approach is entirely different in the insolvency proceedings, in the mediation proceedings. Now, it is also, I think, a very efficient and a very human way of dealing with this complex problem. Because of the accommodation that it offers, because you sit across the table, the mediator will guide you on what is to be done, what is the best way forward. And let me tell you, I am not speaking off the cuff. I have known at least of 2 or 3 incidents where Justice Sikri, acting as a mediator, has resolved the insolvency proceedings and the notices have been withdrawn in 1 or 2 cases. I think one of them was Intech Capital, if I correct. Yes, that is in 2018 or so. Yeah. So, great results are possible, and it has happened. It's just that this moment has to take off, and I am sure with the backlog that we have, with the thirst for success, everyone wants to succeed today. No one has the time to wait. No one wants, as previously said, that the litigation should be passed on to the next generation. They want an immediate resolution of the dispute, and they want that the company should have a second chance of life. I think we as Indians have to get used to this, that even if a business venture fails, it must be given a second chance. Maybe it succeeds the second time if it failed the first time. So I think this is a great tool, a great concept which needs to be promoted. I am very happy that Justice Sikri and Sumant Batra have taken on the challenge to deal with a topic which is just emerging. In fact, this jurisdiction is what I would describe as a sunrise jurisdiction, because I see a lot of potential, not only in insolvency, but also of use of mediation in insolvency. Therefore, it's a credible work on the interface between mediation and insolvency. I congratulate you. I think it is path-breaking. I don't think there are many, many books on this aspect. So I congratulate both the authors for the path-breaking step that they have taken. And I believe this is time for transformation, and this is a transformative approach which has been suggested by the authors. A lot of experts have contributed. Number of chapters have been written by experts. And I'm sure it will be a great tool, a great base book, if I were to call it, a referral book for scholars to develop and to, improve their skills with regard to mediation in insolvency. Thank you very much for inviting me and for making me a part of this book launch, sir. Thank you very much.
Thank you, Justice Manmohan, for the enlightening address. It is now time to invite our chief guest for the evening, Justice Suryakant, to please come and address the august gathering.
Slightly deviating from the format of protocol, I will first address Dr. Justice A.K. Sikri, former judge of the Supreme Court, and my evergreen Chief Justice, Justice Manmohan, Chief Justice Delhi High Court, judges from Delhi High Court, Mr. R. Venkatramani, Attorney General for India, Mr. Amitabh Kant, G20 Sherpa, Mr. Sumant Batra, President of the Insolvency Law Academy, Mr. Sumit Malik, President and other office bearers of the Delhi High Court Bar Association, senior advocates, distinguished mediators, members of the legal fraternity, ladies and gentlemen. It's undoubtedly a privilege and honor for me to be here with you on the launching of this book, as rightly said, a game changer. I'm thankful to Justice Sikri and Mr. Sumant Batra for giving me this opportunity to be with you on the launching of this book. Justice Sikri in his speech hinted how the courts are overburdened, and right from the district courts to the Supreme Court, we keep on talking of dependency, the areas, the timeline within which we'll be able to address those pending matters. Mr. Amitabh Kant, in a very eloquent speech, he highlighted the importance of the IBC as a legislative mechanism introduced for the fast and speedy and timeline disposal of the commercial disputes. But then he also flagged the issue of penancy before the NCLTs or NCLAT, and how the timeline prescribed in the statute is not being adhered to, maybe on account of the overburdened institutes. And it is in this backdrop that the importance of mediation in the field of, or in pursuant to the, in a branch of litigation, commercial litigation, I would say, the insolvency, the importance of mediation arises. When we talk of insolvency, basically it's a stage of a commercial dispute. When you are unable to resolve the dispute amicably through your coordination, your negotiations, or maybe through other different platforms, then eventually the dispute will end up before one or the other adjudicatory forum. And insolvency, of course, is that form or that stage of the dispute where the parties in a way are in a mood to fight. And still then we think of introducing the insolvency, the mediation as a tool of resolving that dispute. So why mediation can be a successful tool even in the matter of resolving the insolvency disputes? I find 3-4 reasons. One, the creditor is very keen that he must get back the amount which he has invested or which was borrowed from him or which he lent that amount. The debtor is very keen to rebuild the business. The shareholders are, of course, again very keen to safeguard their own stakes because they have also made investments in the business. The operational creditor are also under a lot of fear that in case their supplies, the long-term business relationship is come to an end, ultimately their industrial unit or whatever services they are providing into the industry, they will also be in danger. And that fear in all the stakeholders is the real platform, the ground on the which will definitely invite the parties towards mediation. But there is another very important investor to whom I call the invisible investor in this entire scheme of commercial dispute. And that invisible investor is the state itself. If the industrial units will come to closure, if merely because through the insolvency processes the business can be auctioned, can be dismantled, and ultimately whatever scrap is left that can be sold, who is the last end loser? The last end loser is the economy of the country. Mr. Amitabh Kant talked about that how we will be able to achieve our target of Viksit Bharat in 2047, and for that how much economic development the nation is required to have. That can only be done if we are able to save our industry, our businesses, our services. And therefore the importance of insolvency comes, in the matter of insolvency, the importance of mediation comes into. Like any other commercial dispute, we should be with free mind ready that mediation can be an effective tool even for resolving the disputes which have reached the stage of insolvency proceedings before the tribunals or before the appellate tribunal. Having said that, the advantage of mediation, as the learned Attorney General pointed out, the earlier speakers also pointed out, let us have the mediation completely liberated from any kind of format procedure. It must always be kept completely flexible procedure, where you never know on what point the parties may come to a settlement. And therefore, the mediation itself should be a very speculative procedure, that even if you failed at one stage, the effort should continue, you may succeed at the second point of time. So the mediation will have always that advantage, that it's not failure at one place or at one stage of the dispute is not the closure of the door. There is always a room available, there is always a scope, there is always a possibility of the parties again entering into a kind of settlement. And this has happened, and every day it happened. Even at the level of the Supreme Court, we are seeing that the parties who have successfully failed, I would say, repeatedly failed, they eventually come and realize that what is the importance of settlement. All of you know the importance of settlement is what? We have always said that compromise is the soul of justice, and compromise is the mediation. Therefore, mediation always has a part of our social value, our social fabric, our moral values, a part of our civic society, a part of the rules which always regulate the society, whether in the past through panchayat system or through any other regime, till we came to the codified laws in 1947 onwards, when through various statutory provisions we have introduced mediation as a statutory or as a formal mode of settlement of the disputes. We have so many global examples where the insolvency proceedings have been effectively settled through mediation. I recollect the Lehman Brothers, I think, is one of the most celebrated instance which is quoted in the US, where I think 77 areas of disputes were identified, out of which 73 were amicably resolved only through mediation. I think MF, there was one more dispute which was between UK and the US parties. That was also, and the stage was also, there also it was insolvency stage, the MF Global Holdings. That was also a dispute of insolvency stage, where the parties amicably through the mediation were able to resolve the dispute. Justice Sikri must be knowing better than us that in Singapore also it has been successful. So why should we lag behind? And in a country where the litigation has been increasing with the passage of time, people becoming more and more aware of their rights, and most importantly, when the country is inviting direct investments, The investors are coming, our economy is robust and stable, and where there is a lot of attraction for the foreign investors, I think in this emerging scenario, the mediation should be kept as the first-hand tool of resolving the disputes in this emerging field of the commercial disputes, where, as I said, insolvency is only one of the stages where the dispute, as it seems to be, that has gone out of hands, and the party leads to approach the forum for resolution of their disputes. The book, I must say, is an excellent compilation of the best of the brains who have worked in the field of mediation. All the authors who have contributed the articles, I think, have their own expertise and experience in life. Justice Sikri is the leader among them. I can share a small experience that in my High Court, where I have been practicing, and in the days when we were in practice, mediation was not a very popular kind of alternative mechanism at that time. I was incidentally a very firebrand kind of aggressive lawyer, so never thought of mediation as that we will ever be involved in that. I became Advocate General, I was 37, then became judge, I was less than 42. So mediation was not the cup of tea, as I would say, at that time, and we never thought of that it can be an effective tool. But after my elevation as a High Court judge, and in 2005 onwards, and when we started hearing about that mediation can also be something which can be explored for the purpose of dispute resolution. And Mr. J.P. Singh would recollect that when I took over the Judicial Academy, and when Mrs. Ramchandran and Mr. J.P. Singh, they used to come from Delhi, and we used to train our judicial officers with the idea and hope that maybe that some of the matters they will be able to resolve through mediation. So that training part, then at that stage we started really taking interest that yes, mediation can be something which can be through a win-win situation will be able to resolve the dispute. And I must say that with the passage of time, I did realize that yes, mediation is something that's a very effective tool. It's cost effectivity, time effectivity, relationship effectivity. When I said in the context of insolvency, see please people who have set up the industry, they have a lot of attachment also with the industry. There is an emotional bondage with the business you start, and the people want to save that. So when we talk of emotional bondage, we talk of mediation. The commercial disputes, this book is a real guide. It's a very, very effective tool. As learned Attorney General said, this is not a book that you will read and keep in your almirah. This is something, a toolkit which you need to carry with you whenever you are involved in the mediation proceedings. My heartiest congratulations to both the authors and the authors of the 22 or 26 articles contained in the book. Each one of them have really done a commendable job, and they deserve the applaud and heartiest congratulations to each one of them. Thank you very much, Justice Sikri and Mr. Sumant Batra, that you invited me and I could share my views with you. Thank you very much.
Thank you, Justice Suryakant. It is always a delight to listen to your insights. Time has flown by and we find ourselves at the close of this remarkable evening. But before we conclude, it is essential to acknowledge the contributions that made this gathering possible. I would now like to invite my friend and colleague Nilofer Bhateja to deliver the vote of thanks.
Good evening, everyone. This was quite an evening. Although we are running beyond schedule, so I am going to keep the vote of thanks short and sweet. We hope our audience today were both enlightened and entertained by listening to the words of wisdom of our esteemed chief guest and of our guests of honor. First, I would like to thank Justice Suryakant for agreeing to be the chief guest and for releasing the book. Next, I would like to thank Justice Manmohan, Mr. R. Venkatramani, and Mr. Amitabh Kant for taking out time from their busy schedules to grace this occasion and for their esteemed presence and their words of wisdom. To the editors, Justice Sikri and Mr. Suman Batra for trusting EBC to do justice to their book in a very limited period. Next, to Mr. Sumit Malik for attending the event and for his constant support and mentorship. To the EBC team, including Prachi, Bhumika, Anushka, Shubhra, Kriti, and Apurva, who were instrumental in putting together this event. To Ms. Mehdehi Gulati, Mr. Shiv Malang, and the rest of the ILA team for their constant support. Not to forget the staff at S Block Auditorium, especially Rajesh ji and Vipin ji, for helping us in hosting this event. And last but not the least, I would like to thank our wonderful audience for being with us on this occasion. With this, I would like to declare the end of this event. I would like to request our panelists and all our guests to proceed for high tea in the hall nearby. Thank you, everyone.